Welcome to Real Estate Syndicator Live 66, and I hope you're ready for my rant. I've got so much energy behind this topic. I decided to do a solo podcast. Of course, we're talking about fund of funds, which, by the way, just to go on record, I'm a big fan of fund of funds, but I believe that people aren't thinking through it properly. So today I wanted to talk about the three biggest mistakes I'm seeing people do with fund of funds, right? And again, I'm a big proponent of fund of funds. You know, this became an issue, and more people are starting to do fund of funds because, you know, back in 2020, 2021, especially in the middle of COVID, a lot of people were doing sort of the co-sponsor thing, right? They all were trying to raise money as co-sponsors, and you guys know how uncompliant, if that's the right word, or illegal that was going on, right? How many of you guys know someone that was approaching you or heard about somebody that was getting compensated just to bring in the capital for the GP, right? You'd even see those emails. I got those emails all the time that said, look, hey, if you can raise 500 grand into my syndication, I'll give you 5% of the GP. And if you raise $1 million, I'll give you 10% of the GP. I mean, a lot of those violations were going on. And what I was saying at the time, and a lot of my colleagues were saying, hey, why don't you guys just do a fund to fund? That makes more sense. If you're doing that properly, there's a way for you to be able to get capital into other deals. But unfortunately, what I'm seeing now is this has become a big issue. And I think a lot of people just aren't thinking through it. So I just want to highlight some of the biggest mistakes that are out there. And I'll just start right off with number one. And by the way, then we'll get into some Q&A. It'll be a short rant, I promise. Drop questions in the chat and I'll get to them. There's some that's already pre-submitted. But the first one is not realizing, the first mistake is really not realizing that you are an investment advisor. And so I wanted to go through, let me go through this example here of a schematic, because I've talked about this before, and I just want to make sure people understand what's going on here. So this is a typical structure when you're doing a fund of funds. You've got your fund right here in the green that's taking money from investors right here, the Class A members. You're coming in as your carried interest. So this is the syndication fund, or the actual fund of funds, and it's taking money and investing in other people's syndications, right? And so what the law, what most people don't recognize, is that what the law says is, because you're over here as the fund manager, you are advising your fund as to the purchase of securities. Because remember, you're no longer buying real estate like we were before, where the syndication LLC would buy a piece of property and that's what you'd be syndicating. Here, you're buying shares in other people's companies, right? You're buying LP units. And at the end of the day, your fund will be an LP unit in these underlying syndications. So they are buying securities, just like you're buying shares of Apple or Google or whatever. You're buying shares in these underlying companies. And so that makes you an investment advisor. And that triggers questions, I guess is the best way to say. The questions would be, and I'm sorry, I should have probably blown that up a little bit. Do you need to register as an investment advisor? Do you need to do anything? Do you need to do that at the federal level, at the state level? Like what do you need to do at that point once you realize that you over here as a GP are advising your fund as to the purchase of securities, making you an investment advisor? So that's question number one. And the answer to that depends on how much money you're actually raising, or how much money you've raised in the aggregate, right? Because if you've raised less than $100 million, which most of us have, that's what most people are, then you're not even eligible to register at the SEC level, at the Securities and Exchange level. You have to register at your state level, right? And not that you have to register at the state level, we just have to look at your state. Where are you physically located? Where are you advising your fund over here? What state are you located? And then let's go look at the state laws in that particular state to see if there's an exemption to having to register as an investment advisor, because we really don't want to, register as an investment advisor if we can. And so that's kind of the analysis you need to do. You need to figure out, where do you live? What state do you live? And then let's go and look at those states and figure out the exemption. And this is probably the biggest mistake. I don't think people are thinking through that or even are aware of that. And they're just doing it. But there's a great website, and I've also mentioned this before, but there's a great website. My good buddy, Alex Davies, has a great blog called Strictly Business Law Blog. And we talked about this before. Again, I should probably show you this a little bit better. And he has a great, under the guide section, he's literally listed every single state right here in a summary chart, like every single state. So you can go to this website if you want to take a quick cut and see what state you're in and find out what your exemption is. Now, the good news is that these generally fall into three categories, unless you talk the fourth category, like Alabama. Actually, the first one here doesn't even have an exemption, but most of them have exemptions. Some of them don't really care, right? So some of them some of the states don't care that much. They're like, as long as you're not having more than 5 of these fund of funds, like a state like Pennsylvania, as long as you're not doing 5 of these, then we don't really care. You're going to be exempt. We're not going to consider you to become an investment advisor. So as long as you're doing less than 5 of these, or maybe in some states less than 15 of these, you're good. And most of us are doing 1 or 2. So that's quite simple. Then there are other states that are a little bit more onerous, like Texas. So I wanted to share with you the Texas one. If you just go down here to Texas, you'll be able to see, a lot of you guys are in Texas, but if you got down to Texas, I always give that example. I can get all the way down to T. If you read through this, what you'll notice is that you are exempt in Texas so long as all the investors that you bring in are accredited investors, right? What we're looking for here, let me just go over here probably. What we're looking through here is if you, the GP, are located in Texas, then as long as you're Class A investors, your investors are all accredited, then you don't have to register. That's their prerequisite, right? As long as you're not accredited. And so that's relatively simple. I mean, that's not the end of the world. And then there are other states like Massachusetts or Washington that have even more onerous terms. Like you don't have to register into those states, but then all of your investors have to have a minimum of $2 million in net worth as opposed to $1 million, or may even have to be like an institutional investor like in Washington. So it's just state by state. It's not the end of the world. I would highly recommend take a quick look at Strictly Business Law Blog. Alex updates this pretty regularly. Some of these are a little bit more outdated, 2016, but it's just a really good first cut to determine whether you are abiding, whether you have to register in your state, which, by the way, it's not the end of the world. I mean, if you're serious about doing this business and you want to do this and raise tens of millions of dollars, maybe that's the way you want to go. Maybe you go get yourself, I'm not even sure which exact license, if it's just a Series 7 or a 65, but you can just become an investment advisor, register with your state, and now you're able to do this without having to worry about the state exemption. So as long as you've got less than $100 million, you can do that through your state. Once you get above 100 million, you might be required to register under the SEC level. But again, not the end of the world, but just keep it in mind. That's my big thing. So not realizing you are an investment advisor is by far, I think, the first mistake that people go through. And by the way, I'm just realized that I am going to, let me just see where this, what did I do with my slides here real quick? Oh, here we go. Okay. So anyway, so that's number 1. So number 2, the biggest mistake is getting compensated separately directly from the sponsor. So let's go back to my example here of the traditional thing. All of your compensation here and here has to come through the fund. You cannot have the sponsor of the underlying entity pay you directly, either in shares of a GP or cash or whatever, for bringing in $1 million. Or whatever the number is, right? Because then you're getting paid just like you did with the issue with the co-GP. You're getting paid a commission. You're getting compensated for bringing in money into the fund, and you're not a broker-dealer. So you're acting as an unlicensed broker there. Every single piece of compensation that you're getting, whether it's an asset management fee, an acquisition fee, what have you, or a carried interest over here, has to come from the fund. So the idea is that you actually negotiate better terms with these underlying sponsors and say, look, I'm coming in with $1 million. I'm not a $50,000 investor. I'm not a $100,000 investor. I want better terms, which will generate more income for your fund. And then from that excess income, you're going to get your distributions, or your share of the distributions, or your fees. That's how you justify your fees. Otherwise, these poor investors here are going to be, diluted and get double feed, right? They're getting feed here at this level, and then once they get here, they're going to get feed here. So you've got to be really careful about not getting direct compensation here merely in order to put money into the fund. So that's really something important. You want to make sure all your compensation is going through the entity. And then the last one which is this might sound a little bit off, but not working hard enough to avoid a disguised commission. And this is the big one that, again, I'm not saying people are doing it wrong, but I just think people aren't thinking through that. So I want to go back to my schematic here. If all of you're doing, remember when we talk about in other aspects of the law, like the SEC doesn't really care how you structure things. Like when we talk about a security, is this a security? Is it not? Do you need to do this, that? Their definition of security is really broad, and the structure itself doesn't matter. Something similar like that applies here. The structure itself doesn't matter. So if you are simply raising money, right? If you're over here and you're just raising money into your entities and just giving it to another sponsor, then you're just acting as a broker. You're just raising money for that sponsor. And if you just come up with these smoke and mirrors and a bunch of entities here and there, it's going to be difficult, I think, for you to argue that you're not acting as an unlicensed broker, just like if you didn't have these entities. So just because you've created entities and you've created a syndication and you've done a PPM, that in and of itself doesn't get you around the fact that you've got to work hard to make sure that whatever compensation you're getting here isn't looked at as kind of what we call a disguised commission, because you've just created all these entities and funneled all the money through your fund and the Class A and taken fees. But at the end of the day, all you've really done is raise money from these investors to give it to a sponsor, and you're just the middleman or middlewoman, right? And so that's when you hear me talk about it, like, okay, you've got to really start asking yourself or being able to justify, like, what are you really getting paid for? Because you can't get paid for just, raising the money and giving it to this person. You're going to have to do a bunch of other things. And that's when we talk about, obviously you're going to be doing the due diligence on behalf of the investors. But when I say due diligence, you're flying down to the property, doing a walkthrough, something that the investors typically couldn't do. I was talking to somebody yesterday, I don't know if you're on the call today or not, but they were raising money into their fund, and they were investing in other funds that had really high minimums. Like the minimums were, one of them, I think minimum was $5 million to invest in the deal, or the other one was $250,000. So, your investors probably don't have $250,000 to invest in a deal. So no matter how great the deal is, they don't have access to that deal. And so you're providing that access. An example I'm starting to give these days is, I'm a big fan of the new Twitter, and I'm like, I'd love to invest in Twitter. So the next time Twitter does another, private equity round, the minimum investment is going to be $250 million or $500 million, $100 million, or whatever the number is. I'm not going to be able to do that, but I'm going to be able to access that investment through a feeder fund where the investment might be $100,000 or $250,000. But if it wasn't for that fund, if it wasn't for that fund manager, I would not be able to actually even get access to the investment. So that's another value that you're adding for your investors. And then the big one, in my opinion, going back to my little chart here, is that you typically negotiate better terms. And I think this is one of the things that I also see people get caught up with. Like if you're putting in $1 million into one of these funds, then you should be negotiating better terms, discounts on the acquisition fees that they're charging you, discounts on the carried interest, instead of being a 70-30 split, it's an 80-20 split for you. So your fund gets, 30% of the funds instead of just 20% that everybody else gets. Or maybe you're negotiating a seat at the table. Like, hey, I want to be part of these quarterly meetings, any major decisions. I want my voice so I can help. So you're just trying to add more and more value here. And so that you're not just simply, just turning around and flipping stuff. One of the things I've noticed too is, a lot of times the fund manager here, especially if they're just investing in one deal, they're like relying on the underlying sponsor for all of their due diligence documents, for the underwriting, for the back office. You really have to be an independent fund manager here representing your investors. You have a fiduciary responsibility to your investors. So you want to make sure that they are, that you are representing them and basically negotiating against the sponsor and fighting for your investors for better terms, relying on the underlying sponsor for all the underwriting and back office and, their walk through the property and all that stuff. You're going to have issues there because you're not representing your investors in sort of the due diligence. So those are basically the three big issues I have. I'll just throw out a fourth one. Just, it's more not a mistake, but just remember, when you have a fund like this, a fund of funds, you're an investment company. You're just basically a passive investor at this point. So you've got to make sure you get around or try and make sure you don't qualify under the Investment Companies Act of 1940, because that's another whole level of regulatory nonsense you got to deal with. So that's where you hear this 100. The easy exemption there is 100 investors. If you have less than 100 investors, then you have a 3C1 exemption, which will get you around that. So most of us get around that way. I think that one people trip into it because they don't really realize it, but they get away with that. But in any event, that's kind of my rant. One of the things I preach, and again, to be clear, I advocated for funded funds because this is a way better model than coming in as a co-GP and not doing anything other than raising money. But I just don't know if people, actually, it's not that I don't know. I know people don't know what all these other exemptions are, because when I have these conversations with folks, when I talk about the Investment Advisory Act, I talked about, disguised commissions, I get this, deer in headlights look, because it's the first time they've ever heard of it. And it's not like, oh yeah, no, I'm aware of that, and I'm getting this exemption, or I've worked with my attorney, but they literally have no concept of this investment advisory rules and the broker dealers and the Investment Companies Act. So anyway, that's my rant. 15 minutes. I like it. I've got a bunch of questions pre-submitted that I'm going to go through now one by one. But if you're here live, I want to give you guys priority to that. So if you've got a question, drop it in the chat. I see Gail here. Hi, Gail. It's good to see you. And that's my take on the fund of funds. Let's go through a couple. Let me just actually tell you what questions we're going to go with. We're going to talk about what is a typical entity structure for syndication, which we kind of went through that a little bit. What reasons might someone have not to set up a Wyoming LLC? That was a quick question. How do I get soft commitments without talking about details? What does it look like when investors come in months down the road? So you're starting a fund and now you get investors a year from now or 2 years from now because you've got an open fund. What does that look like? I thought that was a great question. How soon can I start pitching my investors after we engage you? Thought that was cool. And then best advice for finding investors. So that's kind of what the goal is right here. And we will start with question number 1, which is, what is a typical structure? Well, let's go back to our fancy little diagram here. And this is basically your typical syndication. Now, this is a fund structure, right? So you would eliminate so forget about all these underlying structures, but basically you have a syndication LLC, which is your main structure. And then that's going to just own the property directly. So that's why this is kind of just erase all this stuff over here. You've got your syndication LLC will be the property LLC. I sometimes call it too, because it's going to own the property. And that's something I typically set up in the state that the property is located. So if the property's in Houston, Texas, this is probably going to get set up in Texas. If you're buying a property in California, it's probably going to be in California. And this is also the LLC where you're raising the money. So you're raising capital into this syndication LLC, which is really technically the security that you're issuing your investors. And then that syndication LLC, as any LLC has 2 parts to it, right? They have a members and they have managers. We use the GP LP analogy, but vernacular, and that's fine, but that's not really an accurate description. A GP LP is really if you had a limited partnership. Most syndicators set them up as LLCs. So what you have is a manager, which has no ownership at all. The manager just manages. You're hiring the manager to be the sponsor basically and do all the work. And in exchange for that, they're going to get asset management fees. They're going to get acquisition fees. They're going to get whatever fees that you guys have in the deal. That's going to go to the manager. But the manager doesn't own anything, by the way, doesn't own any shares in the syndication LLC, really doesn't own anything here because this is the company that's going to get sued. If this thing goes south, this is really the company that's making all the decisions. That's really who should get sued. I don't want that company owning 20% of this or 30% of this or anything else really other than a bank account and an insurance policy, ideally. And then the syndication LLC, typically we have 2 members, 2 classes of members. One is your investors, which usually are the vast majority of the membership, usually 70, 80%. We usually call them Class A members. That's really the investors who are wiring you money, and those are the people that you're issuing securities to. And then your cut of this, we call it sometimes sweat equity. Technically, it's called a carried interest. That's the remaining 20, 30, 15, whatever over here. And that's usually a separate class of membership. And the reason you want to keep those separate is, number one, you want all the voting rights, obviously, right here in this membership class, so that you keep control of everything. You hire and fire the manager. You basically keep control. And then to the extent you want to give your investors any preferential treatment, like preferred returns or waterfalls or whatever, it's just easier to do when you have a couple of those. So that's your typical syndication structure. It's really, for you, it's 3 entities: syndication LLC, a management company, which is really the GP, and then how you hold your interest. And then the end of the other entity is just the investors. Off topic. Let's see here, Mike. I'll tell you right now, Mike. I don't know the answer to that. I'm not an IRS. Off topic, but I got a serious question. Can you set a TSP rollover to a self-directed IRA with no penalty? That's a CPA question, my friend. I honestly just don't know. This is an interesting one. If you're setting up a fund of funds, but you are out of the country. Okay, well, let's talk about that, because I think one of the questions that was submitted had to do with international investors. But this is like if you're physically out of the country, and I don't know where you are. My mood today won. But it really doesn't matter where you're located. It matters where you're in, or actually where the property is located or the project. What matters is where are the investors located. So even if you're outside of the country, and let's say you're raising money for a deal that's in Central America or somewhere else, doesn't even matter. Like, where are your investors coming from? If your investors are U.S. persons, U.S. individuals, then the securities laws of the U.S. will apply. The only difference, I would say, and maybe this is where you're getting at in terms of if you're international, is on the investment advisory side, right? Because if you can't register at the SEC level and you have to register at your state level, but you're off in Spain, right, doing all of this stuff, then obviously you're not going to. There's no state compliance for you to worry about. Now, you might have some issues to worry about in the country you're living in, but you wouldn't have to worry about a particular state, because the state that we're talking about is the state where you're physically located, because that's where you're giving advice to your client, and your client is going to be the syndication LLC. So great question. Maybe this is the follow-up too. Out of the country, do you choose the state based on where registered? No, you're out of the country. So you're advising your fund from outside the country. There's actually a foreign advisory exemption. I forget the exact name, Foreign Advisory Exemption or Foreign Investment Advisory Act. So you wouldn't have to worry about the state stuff. Now, again, once you get to 100 million, then there might be a registration at the federal level. But if you're physically located outside the United States, then there's a lot of stuff that you generally don't worry about at the state level, because the state only has jurisdiction over you where you're physically located. All right, let's go on to the next question here, which is, what reasons might someone not want to set up a Wyoming LLC? This is actually a cool question, because I've got an update for you guys, which I'm about to make some content about. So the update is this. As of September 1st, so literally, 16 days ago, you guys from Texas are going to be happy. The great state of Texas has passed law that basically extends the charging order protection, which I'll talk about briefly, to single member LLCs. So Texas now joins the big three, which we usually talk about, which is Nevada, Wyoming, and Delaware, as the only states. Now, Texas is the only states that extend the charging order protections to single member LLCs, which is a big deal. So one of the reasons we typically set up things in Wyoming is because I really don't have a dog in the fight. If you want to do Wyoming, Delaware, or Nevada, usually Wyoming is cheaper. Wyoming's got some better privacy things that you work with. But if you're physically, not too many people live in Wyoming, right? So usually it's an out-of-state person with a Wyoming holding company. But if you live in Texas, I have already started recommending when you set up your holding company, whether it's for your syndication or it's for anything else, you might as well set it up in Texas, because you have the exact same benefits from an asset protection standpoint as Wyoming, Nevada, and Delaware. Now, the privacy is an issue, right? So if you're concerned about privacy, which some of us are, I'm a big privacy guy, then you're going to have to add a couple more layers to it. But there's ways for you to have the privacy in Texas. Texas requires you to put down who the managers are of that particular state, but you can create a Wyoming management company so that when you file your documents with the state of Texas, you put a Wyoming LLC there as the manager, which doesn't trace back to you, and you obviously want to hire a third-party registered agent, so your name's not going to be anywhere in the public record. So if you're a big privacy person, you want to make sure that we can definitely accomplish that. But Texas, I know a lot of our clients are in Texas, so if you're somebody in Texas, I would. So that's one reason I would not set up a Wyoming LLC. And by the way, the Wyoming LLC is only for holding companies, right? So when you're doing asset protection, some companies are operating companies, businesses. Those get set up usually in the state where you're doing business. So if you're doing, that's why the syndication LLC or the property LLCs typically get set up in the state where the properties are located. If you have a management company, your real estate business, that's going to be set up in the state that you reside. But your holding company, which is the one that owns all of your safe assets, owns your LLC units, kind of is that top level entity. That's the one that we usually have in Wyoming, or Delaware or Nevada. And now I'm going to add the great state of Texas to that number. Mayura, I hope I pronounced that. Sorry if I pronounced that right. I have a basic question. What is the definition of fund of funds, and does this definition change from state to state? No, a fund of funds is literally a fund. Let me give you the layman's term. It's a fund that invests in other funds and other syndications. So instead of raising money into your fund, which we don't really call them funds usually, but if you're raising money into your LLC and then you go buy something directly that you're doing, you buy a piece of property, you buy a stock, you buy whatever, then that's just a regular fund or a regular syndication. But the minute you start investing in other funds or other syndications, that's what we call this fund of funds, because you're a fund that then invests in another fund, if that makes sense. So that's definitely, and it does not matter what state differentiate from state for state. What differentiates the state to state was the first mistake, which I'm not sure if you were here for that. It's just simply, you're an investment advisor when you're doing a fund of funds, and do you need to register in your particular state, or is there an exemption in your particular state? But as for the definition, it's going to be a fund of funds. It's going to be the same across the board. All right, next question. What do we have here? How do I get soft commitments without talking about details? That's a tough one. I get this all the time. And my answer is it's very difficult to get soft commitments without the details, because you can't really give them too much information without first having your SEC attorney review whatever documents, spreadsheets, whatever you're giving away. It's very difficult for somebody to commit or a soft commit just based on general information. And so that's one of my concerns that I generally have as well. And this is separate from the funded funds, but one of the concerns I always have is our clients or even other people going out there and talking about their deal, showing pitch decks or showing spreadsheets to individuals, and they haven't had that reviewed by a securities attorney. They don't have any disclosure documents. So you could be out there making offers to people without having the proper disclosures, which is I always recommend that even your business plan, you want to make sure your SEC attorney reviews that business plan first, gives it the go ahead, puts whatever disclaimers needs to go in there, has looked at all the language. And then once that happens, you can start showing that to investors. But the reality is all you really can do at that point before you do that is talk generally about what you're thinking. Like, hey, I'm looking for some multifamily properties in the 50 to 100 unit range, or for the 10 to 20 unit range in the Houston area or this area. And you can kind of give very vague parameters. And the discussions you're really having with investors is that something you're interested in? Is that something that if I find something like that, is that something that that you're interested in? But once you already have something tied up, you really shouldn't be talking any specifics about that deal until you've had at a minimum your business plan or your one sheet or whatever you're going to be presenting or showing to an investor through that securities attorney. Once that happens, I'm comfortable you sharing stuff. I don't believe that you need to have the full-blown PPM every time you talk to the investor at the beginning. If you've got that business plan with the proper disclaimers to say, hey, look, this is for informational only. You can't invest until you've reviewed the whole PPM. We have that disclaimer language that you can show. But I'm very wary when people start showing even spreadsheets to potential investors without, having the deal into contract or having an SEC attorney review that. Let's see what we got over here. Vessi. Hey, Vessi, how are you? Let's see here. Let's do it this way. If your fund is investing in a 506B deal, do your non-accredited investors count towards the 35 non-accredited investor cap, or is your fund considered accredited based on size? All right, let's talk about that. So whenever you're talking about accredited and not, by the way, it's a great question, Bessie. Anytime you're talking about accredited versus non-accredited, you have what we call a look-through provision. So from your perspective, it probably doesn't affect you because you've got that limitation anyway. So if you're doing a 506B into your fund of funds, you're limited to 35 non-accrediteds, just like everybody else. But for the person that you're investing into, that person, if they're doing a 506B, also has a 35 non-accredited limitation. And if you've got, and say in your deal, you've got 10 non-accredited investors in your fund, that's going to count 10 against my fund at the lower level or the higher level, however you want to do it. So there's a look-through provision. So the underlying sponsor who's accepting you as the fund has to be aware of that and wary of that and wants to make sure that that they're counting that. That's why they're going to send you a questionnaire. They're going to ask you, how are you accredited? Are you not accredited? And they're going to ask you how many non-accredited investors are in your deal. What typically happens too is, obviously if the underlying investment is only accepting accredited investors only, whether it's a 506B or 506C, if their limitation is we only accept accredited investors, then the only way you would be able to qualify as an accredited investor is if you had, unless everybody was accredited in your membership, that you had $5 million in assets under management that were not raised for the specific purpose of that investment. So if you're raising them $5 million, that's not going to work. That usually is for, the example I always give, if you're a medical practice or whatever, and you've got a bunch of doctors and you happen to own a building and that building got more than $5 million in equity, then that LLC or that LP would be accredited. But generally speaking, you're talking about having that, in order for your entity to be accredited, all of your investors, all of your members have to be accredited. I was going to say something controversial, but I won't. So I think that answers your question. Or is your fund considered accredited based on size? So the only time it would be based on size is if it had $5 million in assets that were not specifically raised for the purpose of that particular investment. I think that answered your question, Bessie. Gail, hey Gail, how are you? Triple Q, our fund to triple Q, but our fund to funds only limited to accredited investors? No. Well, before I say no, generally speaking, no. You're certainly entitled under Reg D, and you can have a 506B fund of funds, right? You could raise money with up to 35 non-accredited. You could do a Reg A fund, right, which is what a lot of people do, and that way you'd have theoretically unlimited non-accredited if you got it approved. The restriction is going to be at the state level on the investment advisory side. So we talked, again, I'm not sure if everybody was there at the beginning, but the limitation would be like if you're in the state of Texas, to give the example, you could under 506B, you wouldn't have the issue, but under Texas, you would be limited to accredited investors only in order to get that exemption of not having to register with the state of Texas as an investment advisor. So either you had to get everybody as accredited, or if you really wanted to insist on having non-accrediteds, then you just get yourself, you register with the state of Texas, which again, I haven't done it personally, but everybody I've talked to who have, or attorneys, say it's not that complicated. Yes, you are under a lot of additional regulation and that stuff, which is no fun compliance-wise. But in terms of actually getting registered as an investment advisor in any of these states, especially Texas, you're literally passing an exam, you're setting it up, you're paying fees. But again, compliance, audited financials, whatever. There's issues there. But no, you can have non-accredited investors, but you're going to have to be in a state that allows that from an investment advisory. Otherwise, you'll violate the investment advisory rules. Gail, I heard the definition of accredited is changing. It is. I just did a video on that. Actually, it's probably one of my best performing videos on accredited, so I'll spend 10 seconds on it. But there's two things that are happening. Number one, SEC has already passed a rule that says you're going to be able to get accredited by passing an exam. And Congress has now passed two laws, the Accredited Investor Definition Act and the Investment Opportunity for All Act, I believe it's called, which also are saying you can get accredited with a test. Congress, it's only been the House, it's sitting at the Senate, so that hasn't passed, it's not law. And even when it becomes law, it's going to probably, the rule itself says you've got 1 year to implement it. So we're a little a ways from the test. And then the rumors have it, word on the street is that whenever the SEC gets to this updating the definition, it's on the agenda now for October, that they are going to be raising the accredited investor limit from $1 million to something. We don't know what it is. I've been speaking quite a bit on my YouTube channel about $3 million, just because that's what $1 million is adjusted for inflation back to 1982, which is when the rule passed originally. So anyway, so that's, but it is changing. So I think you're going to have a dual path. You're going to either automatically qualify as an accredited investor, but that number is going to be higher, let's say 3 million. And if you don't qualify, if you don't have 3 million, then you can go take a test. I think that's where we're going to all end up. That's not going to happen though until probably middle or late to next year would be my call. All right. Great questions. Keep going. I'll keep going with the pre-submitted, but if you've got another question, I think I've gotten everybody so far. I want to give priority to you guys that are here live, so really appreciate it. And hey, if you're getting any value from this, would appreciate a like and a subscribe. It really helps us out for everything. All right. Next question. What does it look like when investors come in months down the road to invest in your fund? This is another great question. This is a scenario where you have a fund, doesn't have to be a fund of funds, just any fund, where either you don't, it's an evergreen fund, you just constantly have it open, right? People are coming in all the time, or it's just taking you for whatever reason, it's taking you longer than you thought to fill up the fund. So you thought you were going to raise everything in a couple months. Here you are 8 months later, 9 months later, and people are still coming into the fund. What does that look like? And there are a couple of things you've got to be aware of when that happens. And the main one, I would say, the main one actually that most people, again, don't realize is if you bring in non-accredited investors down the road, you're likely going to have an obligation to give them audited financials. The reason for that is that it's right there in the rule. 506B and C, Reg D requires you to provide your non-accredited investors with audited financials. Now, in their usual syndication, it's a brand new company. There are no financials, let alone audited financials. But if you have a fund that's been operational for 6 months, 9 months, or a year, and now somebody comes in a year later, well, hey, you've got a year's worth of operations, and you're going to have to provide your non-accredited investors, not the ones that are already in, the new people who are coming into your fund with audited financials. So keep that in mind, because that's obviously a cost. And then if you're thinking about doing this from the get-go, you've got to think through pricing, right? Like if you know you're going to be open for 2 years, does the person who invests right at the beginning get the same price as somebody who comes in a year from now or 2 years from now? Probably not, especially if you've designed it that way. And so 2 ways to do that. One is a lot of funds are just a flat return. They're like, hey, we're just going to give you 12%, whether you come in today or tomorrow or the next day, and that's all you're getting. And if it's a flat fee return, probably don't need to worry about it, because it matters a little bit. It doesn't matter as much if you're coming in on day 1 or day 100. But if it's not flat and you're getting, it's just an 80-20, return or a 7 pref, well, clearly the person that came in is taking up a lot more risk. The person coming in a year from now already has all the assets that are there. Maybe the assets have matured. The assets have, have some additional equity. And so you're going to have to think through some formula to charge the next person down the road higher. So maybe you start off charging, $1,000 a share. Maybe there's a discount, $900 a share. And then a year later, it's $1,000 a share. And a year after that, it's $1,100 a share. So you can sort of price it up. Or some people just have, what we call a NAV, a net asset value formula that just calculates, how much these properties are appraised or what the cash flow is. I mean, it's some formula that you predetermine so that it's very clear that if somebody comes in next year, the price for those shares is going to be dictated by whatever the current situation of the fund is. So but the big one is the accredited. I think, again, a lot of people don't realize that there is that obligation right in the rule of Reg D, which is if you have non-accredited investors coming into your deals and you're an existing operating company, then you have an obligation to provide them with audited financials, which, as we all know, is just money, a pain. All right. A couple more questions here. And if you guys have a question, please drop it in the comments. What's next here? How soon can I start pitching to investors after engaging with you? I think I kind of answered this already, and that is that as soon as you have your business plan vetted by us or whoever you're using, but in our case, if you're engaging us, we will do a deep dive into your business plan. We'll ask you 1,000 questions, give you a questionnaire, get on the phone, do strategy calls, pepper you with questions. We'll have 1,000 questions, 1,000 comments on your business plan, understanding it. We'll probably go through a number of drafts of your business plan because we'll have 1,000 questions, 1,000 comments. We'll give those to you. You come back with, the next round of draft number 2, we'll do the same thing. And after 2 or 3 drafts, especially if we've never worked together before, we'll end up with a final draft. And then once that's ready, you can now send that out to your investors, do your webinar, do whatever it is you're going to do. They just can't invest, obviously, can't wire you money until all the offering documents are done, private placement memorandum, operating agreements, all that stuff. But in terms of showing people what it's about or your webinar, as soon as you get the business plan blessed by your attorney, I think that's when you can start sending that out. I think this is Vessi again. Hey, Vessi, what do you got? What, if any, is the seasoning period when doing a 506B to 506C conversion? What a great question. So for those of you who don't know, a couple of years ago now, more and more clients are starting to do these conversions where they start an offering under 506B, which is allowed now, and fully comply with 506B. And then at some point in the middle of your syndication, you pivot and you switch basically exemptions from 506B to 506C, and you start doing that in full compliance with 506C. So yes, you can start advertising at that point, but you can only take accredited investors and must take reasonable steps to verify. There is no seasoning period for that conversion. So they're technically, they're really 2 separate offerings. So offering number 1 is a 506B, so we comply fully. And then at some point you make a determination. I like to do a written consent. We do it like a resolution that says today, what is it today? August 16th, 2023, we are terminating our 506B deal, and starting immediately, tomorrow or this afternoon, we are now starting a 506C deal. Now, the reason there might be a little bit of delay is because there are some updated documents. They're very similar documents, but there are definitely some changes to the business plan, amendments to the business plan, and then obviously some language in the PPM that specifically addresses 506C deals. So you do have updated docs, which, quite frankly, there's no reason those can't get done early, so that when you're ready to turn, you just turn. But there is no seasoning period there. I think what some people mistake, or the seasoning people are thinking of, is there is a safe harbor of 30 days, which applies to any deal, by the way. So there used to be this concept, there still is this concept of integration. Like if I have 2 deals and they're very similar to each other, the SEC is just going to look at them as really a one. They're going to integrate them. So you just can't get around the rules. I can't just start a syndication, raise 35 non-accredited, and then be like, well, I'll just start another one and start another 35, right? The SEC will combine those. There used to be a safe harbor period that if you waited 6 months between one offering and another, then the SEC would not integrate them, which was interesting. that got shrunk to 30 days. So, but that's with any, not just B to a C, but even technically a C to a B, you could theoretically do that, because if you stop for 30 days, there's a safe harbor that they're not going to integrate those two. But what I've been talking about, what this specific one references, is when the SEC now allows you to start one under 506B and then mid-raise, same syndication, substantially similar documents, switch over to 506C. You can do that on a dime, because what you're doing is actually terminating one and starting another. I hope that answered your question. Mike, what does it look like? Oh, this is a cost question. What does it look like for a lawyer to look over it? To look over, in general, we don't quote unquote look over stuff. It's just, in our experience, it just takes forever. You know, you're looking at docs that you're not familiar with, and you don't know what all the disclosures are. Like, we have to do the full interview to figure out what are the risks associated with your deal. What are the disclosures we have to do? What are your disclosures? We've got to go through that same exercise, looking at your business plan, understanding your deal, understanding your risk, so that we know what goes in the PPM. Then we got to look at your PPM to make sure those are in there, and then compare it with all the little, small things that we have in our PPM. It's just kind of a mess. So we don't usually review. Plus the liability, like if I didn't draft it, but now I'm just taking a quick look at it, I think the liability there for the law firm is pretty high. So we actually don't look for, we just prepare our own offering documents. So clients come to us, and that'll be, depending on what you're doing, anywhere from probably 10 to 20 grand to have a full blown, compliant offering, not just the docs. Don't get me started on pet peeve on docs. Docs are part of it, but you get docs for a couple grand, right? This is compliance. This is making sure that somebody's looking over. Best way I can, this is making sure somebody's got all the bag of tricks that we're not bag of tricks, but all the law that we have the back of our heads, our little checklist that we go through every so often. That checklist will trigger something and we'll bring it to the forefront. But that compliance part, like on the funded funds, just understanding that, are you an investment advisor? Do you need to register? Like all these questions that we have as lawyers, that's really what you're paying us for. You're paying us for that compliance, making sure we're fully complying with federal and state securities laws. It's not just banging out a PPM that, quite frankly, these days you can just fill out a questionnaire and get a document generated. That's not what I would consider compliance. That's just banging out a bunch of docs. But that's just my own soap opera there for a second. There was a question, I don't know if it's here or not. There was a question about, best advice for finding investors. Look, the one I've seen the most successful clients that we have, and this is everybody's looking for the quick answer, but the reality is, if you can build an audience, and whether that's podcast, right, YouTube, or just getting on LinkedIn, social media, becoming an authority, writing a book, whatever it takes, or just going to your local meetups or organizing your own local meetups, becoming the expert and just getting out there and building an audience, which again takes time, and then having a relationship with that audience, making sure you're connecting with that list, sending them valuable information, adding value to them. That's the easiest way or best way. That just takes time, right? So, but other than that, the time for you to find investors is honestly when you don't have a deal, right? When you're in between deals, or if you've never done a deal before, this is the time you want to be talking to investors, because you've got nothing to sell. There's no pressure. You're having these one-on-one conversations, or you're going to a seminar. Is another great way to meet new people, and is just to go to these seminars. Not for the content's important, but just the people you're going to meet, get into conversations with people. And if you don't have a deal, it just takes away a lot of the pressure. They know that the conversation is not going to end with, hey, you want to give me $50,000 or $100,000. The conversation is going to end, great, now that I understand, Mr. and Mrs. Joe, that this is what you're looking for. If I were to find something like that, is it okay if I reached out to you and showed it to you? It's just a lot less stressful conversation. The guards are down. It's not like, oh, here he goes, he's pitching me a deal, he's going to ask me for money. It's just like, hey, what are you looking for? What are you looking to invest? What's your risk tolerance? Find that out. Start establishing that substantive relationship, and then just finish the conversation with, great, now I know what you want. If I find something, is it okay? You're almost asking permission. Okay for me to send it to you? What are they going to say? No. So that's to me. But to me, the audience is the easiest way. That the clients that have those big audiences are able to raise an incredible amount of money relatively easily these days, especially now that everybody is struggling a little bit more because it's harder. It's still harder, but having an audience is just, and that goes for anything too, right? That goes for, I'm working on a book. And so having an audience to launch a book or to launch a new podcast or launch anything, having an audience really does help. I think I have one more question, and then then I'll see if anybody else has one here, but and I don't think I put it in the slide here. No, I don't. So the other question was just, I don't know how much of you guys are care about it, but it was just like, how does it work with international investors? So I'll spend a few minutes on international, and then if I don't see any questions, we'll call it a day. But so when you're talking about international investors, a couple things come to mind. Number one, there's an exemption for international investors that people may not be aware of. So just like we have Reg D, right, and Reg A, there's a Reg S as in Sam, which basically says, hey, if you have a deal that you don't sell in the United States and don't market in the United States, you exclusively sell to people, non-U.S. persons living abroad, then we have this Reg S exemption, which basically says there's not really that much disclosures in the U.S. level, but they're mostly concerned about you selling it to them and then them selling it back in. But so there's a couple of disclosures you want to put in there, but it's really a fairly simple exemption, the Reg S. The big one, I think, is the tax, right? So you got to remember that when you have international investors, you have the burden to withhold a percentage of the distributions or profits that you're sending back to your investors. And it's a 30% withholding. So I kind of joke that you become an IRS agent because you have an obligation to withhold 30% of the profits that would have gone to them, because if you don't withhold them, they're supposed to file taxes or tax return and pay taxes on that. And they're not going to do that. And so if you don't do that withholding, then you might be on the hook for that tax. If it turns out that they don't actually file the tax return and pay their taxes, the IRS can come after you. So make sure you're working with a really good CPA that deals with cross-border transactions. Just make sure that's there. The other issue that we have with some countries like Canada, for example, we looked at our schematic here with an LLC. They don't recognize LLCs. So, and there's other countries that don't recognize us. So just make sure that where your investor is, that if you're doing an LLC, they recognize it. And if they don't, like Canada defaults that to a corporation. So if you just set up a regular LLC, have a Canadian investor invest in your LLC, what I've been told by CPAs, both here and in Canada, is that'll, on their end, the tax return in Canada will default to a corporation. They're going to get double taxed. They're not going to be happy with you if you didn't alert them or didn't tell them. And there are some strategies that you could use to mitigate that. So you just got to be aware of that. Make sure that the country your investor is located in has LLCs. And the last one I would just say is you are still subject potentially to securities laws in that particular country. So if you're out there in Mexico or you travel to Canada and you're raising capital there, you should probably be checking with a securities attorney in that particular country to make sure you're not violating their rules. I don't know anything about securities laws outside of the US, but if you're traveling to the Middle East or Europe or whatever, and you're pitching people over there, you probably want to make sure that you're complying with there. So anyway, if there's no other questions, I really, really appreciate you guys sticking around, and we'll see you next week with my good buddy Chad Sutton over at Quattro Capital. He'll be joining us next week to talk about how to scale and processes and systems. See you guys next week. Thanks, everyone.